Hi everyone, and welcome to today's webinar on Enduring Powers of Attorney, presented by Laura Muccitelli. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the author. Information is current as at the 4th of June 2019. Today, we are fortunate to have as our presenter Laura Muccitelli, Managing Lawyer at Way Lawyers Brisbane City Office. Way Lawyers is a non-profit law firm that offers affordable legal services to clients from diverse backgrounds. Laura has many years' experience in family law and estate law. She is very well placed to present this webinar, refreshing and expanding your knowledge on enduring powers of attorney. I'll now hand over to Laura and talk to you again at the end of this session. Over to you, Laura. Thank you.
Thank you, Amanda. Hello and welcome to this seminar on powers of attorney. As Amanda has mentioned a moment ago, my name is Laura Muccitelli. I'm employed as a managing lawyer at Way Lawyers in the Brisbane City Office. So the format of today's seminar is that I'll focus mainly on the Act, the Powers of Attorney Act 1988 Queensland. We'll then look at some cases and then questions will follow at the end of this seminar. Okay, first let me tell you a little bit about Way Lawyers. Amanda has touched on what we do a little bit. I'd just like to expand. So yes, Way Lawyers is the first not-for-profit law firm in Australia. We do charge fees, but our fees cover really our operating costs. We don't have any partners, so to speak, as most law firms do. We do have a board of directors. Our fees are generally 1/3 to half less than those charged by other law firms who operate on a commercial basis. One of our key programs that we're very proud of at Way Lawyers is that we have what's called a client care program. This program basically provides support, encouragement, heartfelt messages to clients that we feel need a little bit more support than other clients, particularly in the area of family law. As I said, we are very proud of this client care program. We do have a client care coordinator that's in every office. This coordinator is not a counsellor. It's basically this person's a listening ear that supports these clients and through the court process as well, support person. Okay, now let's talk about powers of attorney. So, what is a power of attorney? A power of attorney is a document by which one person, the principal, authorise one or more other persons, the attorneys, to make particular decisions and do particular things on a principal's behalf. The Powers of Attorney Act 1988 Queensland, as I mentioned, is the governing legislation in Queensland for authorising and exercising general powers of attorney, enduring powers of attorney, advanced health directives, which I'll be talking about a bit later, and also statutory health attorneys. We'll be looking closely at this Act today. There are strict requirements for entering, exercising and revoking powers of attorney, which we will discuss soon in detail later on. The power to act under a power of attorney can be a general power or a specific power. A power of attorney gives the attorney the authority to do many things that the principal may do themselves. There are exceptions, however, to this, and again I'll talk a bit more about that later on. A power of attorney can be used in many circumstances, such as buying and selling a home, collecting debts on behalf of the principal, when the principal is planning a holiday overseas for a time, or in circumstances where a principal has limited mobility perhaps, or believes that another person is better able to manage his or her affairs. So who can grant a power of attorney? Anyone who is over the age of 18 years old who can understand the nature and effect of the document can appoint an attorney. Who can you appoint as your attorney? There are strict requirements as to who is an eligible attorney under the Act. When choosing an attorney, the principal should first give thought to choosing someone they trust. In any event, a person must first satisfy the following requirements before they can successfully be appointed. Number one, they must be at least 18 years old. 2, they must not be the principal's paid carer or healthcare provider. They must not be a service provider for a residential service where the principal is a resident. And this doesn't appear on your slides, but there's also another exception. They must not be a bankrupt or taking advantage of the law of bankruptcy as a debtor under the Bankruptcy Act 1966. This only applies if the principal has given the power for a financial matter. We'll discuss a bit later on what is a financial matter, which is actually defined in the Act. The public trustee and a trustee of a company are also eligible attorneys. The public guardian is also an eligible attorney for personal matters only. So what kind of decisions can your attorney make? An attorney can make any decision about financial and personal matters on behalf of a principal under an enduring power of attorney. Under a general power of attorney, it excludes personal matters. So financial and personal matters are defined in the Act. Schedule 2, Part 1 of the Act defines a financial matter, and Schedule 2, Part 2 of the Act defines a personal matter. These, as I said, are explained a bit more in detail later on. The next slide, we talk about types of powers of attorney. There are 2 types. One type of power of attorney is simply called a general power of attorney. That's defined in Section 8 of the Act. Another power is called simply a general power of attorney. Another power is called enduring power of attorney. It's a general power and enduring power of attorney. That is Section 28 of the Act. So a general power of attorney provides for an attorney to make decisions regarding financial matters on behalf of the principal. It excludes personal matters. As I said, personal matters will be discussed a bit later on. But for an example, a personal matter is where the principal is, for instance, where the principal lives and with whom the principal lives, where the principal works, for instance, and day-to-day issues including diet and dress of the principal. So, what is a financial matter? So under a general power of attorney, it provides for an attorney to make decisions regarding financial matters. Financial matters is defined in the Act under Schedule 2, Section 1. And you'll find that at slide 7 of your Act, of your slides. That is just a direct lift from the Act. Now, I felt it's important to put that in there. So in summary, basically a financial matter is, for instance, paying maintenance and accommodation expenses for the principal, paying the principal's debt, receiving and recovering money payable to the principal, carrying on a trade of business of the principal, performing contracts, discharging a mortgage, paying rates, taxes, insurances, and so on. Otherwise improving and preserving the principal's estate, investing in the principal's investments, undertaking real estate transactions, dealing with land, for instance, and also legal matters relating to the principal's financial or property matters. So, frequently, general powers of attorney is frequently used by people who are either physically unable to manage their financial affairs or would like to appoint someone they trust to manage their financial affairs whilst they're on holiday. There are some requirements for a general power of attorney. For instance, it must be in the approved form, Section 11 of the Act. It must be signed by the principal or at the direction and in the presence of the principal, which is Section 12. A general power of attorney can provide terms or information about exercising the power. And also, a principal may specify when and in what circumstances the power can be exercised. If the document doesn't specify a power, however, it'll begin immediately. That's Section 9 of the Act. And a principal can appoint one or more eligible attorneys or several attorneys. Now let's talk about revocation. So revoking a general power of attorney. As you can see, I've summarised it in your slides. Revocation of a general power of attorney is found in Part 3, Division 1 to 4 of the Act. And these are, number one, the general power of attorney can be revoked by the principal. This is in any instance where the attorney's power has been revoked. However, all attorneys affected by the revocation must be advised, and if the power of attorney has been registered, it must be deregistered in the register. Section 17 states that attorney's power can be revoked by way of written revocation, but the written revocation must be in the form of a legal document in an approved form. Section 18 also states an attorney's power can be revoked by way of the principal's impaired capacity. So for a general power of attorney, it's revoked if the principal becomes an impaired person. Impaired capacity does not just mean the person cannot communicate. If this occurs, the court has the power to confirm the appointment. In the Act, incommunicate means if a person becomes incapable of communicating decisions about that person's financial, property or legal affairs in some way. That's defined in Section 18 of the Act. Section 19 states that attorney's power is revoked when the principal dies. It's also Section 20 is revoked. That power of the attorney can be revoked according to its terms if the power of attorney is expressed to operate for or during a specified period, and if the power of attorney is expressed to operate for a specific purpose. For instance, principal can have a power of attorney appointing an attorney only, for instance, for the sale of their home, for instance, while they're overseas, or the purchase of a piece of land. And once that sale has been completed, then the power of attorney is obviously revoked. Section 21 to 24 of the Act sets out when a general power of attorney can be revoked by the attorney. These, in summary, can be revoked by the attorney in 4 instances. A, the resignation of the attorney, the impaired capacity of the attorney, the bankruptcy or insolvency of the attorney, or the death of the attorney. Section 25 of the Act states that if the power of attorney has been registered in order to revoke the power of attorney, an instrument revoking the power of attorney must also be registered. Next slide, we're talking about enduring powers of attorney. So an enduring power of attorney gives the attorney authority to make not only decisions about a financial matter on behalf of the principal, but also personal and or health matters. So a personal matter is defined under Schedule 2, Part 2 of the Act, and is a matter relating to, for instance, the following. So it relates to where the principal lives, as discussed earlier, with whom the principal lives, services provided to the principal, for instance, what educational training the principal undertakes, whether the principal applies for a licence or permit, healthcare, a legal matter not relating to the principal's financial or property matters. Additionally, an enduring power of attorney authorises the attorney to make decisions relating to health matters on behalf of the principal. Now, a health matter is defined in the Act. It doesn't relate to special healthcare matters, and that's also defined in the Act. with healthcare being defined as care or treatment of, or a service or a procedure for the principal, for instance, to diagnose, maintain or treat the principal's physical or mental condition, carried out by or under the direction or supervision of a health provider. This includes withholding or withdrawal of life-sustaining measures for the principal if the commencement or continuation of the measure for the principal would be inconsistent with good medical practice, and that's defined in the Act. So, enduring powers of attorney, the capacity and requirements. The principal must have capacity to make an enduring power of attorney. Capacity is determined by the principal's understanding of the nature and effect of the enduring power of attorney document. That's defined in section 41 of the Act. That section states that understanding the nature and effect of the enduring power of attorney includes understanding the limits of the power, when the power begins, and, for instance, revoking the power. There's also certain formal requirements under section 44 of the Act for the drafting of an enduring power of attorney. So it must be in an approved form. It must be signed by the principal or if the principal instructs for the principal and in the principal's presence by an eligible signer and be signed and dated by an eligible witness. An enduring power of attorney allows an attorney to continue to act for a principal even though the principal no longer has capacity to manage their own affairs. That's defined in section 32. This is the major difference between enduring power of attorney and a general power of attorney. Section 31 defines what is an eligible witness, and that includes a justice of the peace, a lawyer, commissioner for declarations. It's not also an eligible witness is not the person signing the documents for the principal, it's not the attorney for the principal, it's not a relation of the principal or the attorney, it's not a paid carer if the document gives power for a personal matter, and is at least 21 years old and not a beneficiary under the principal's will if the witness is for an advanced health directive. As I said, we'll talk a bit more about those advanced health directives in a moment. In relation to that, the eligible witness must not be a relation of the principal or of the attorney. Schedule 3 of the Act does actually define what a relation is. So a relation refers to a spouse, a person related to the principal by blood, by marriage, by adoption, by de facto or foster relationship, a person whom the principal is dependent, a person who is dependent on the principal, and a person who is a member of the principal's household. So it's quite broad. So the principal may appoint more than one eligible attorney. This is the same criteria used in the general power of attorney. Section 43 of the Act states a principal may appoint one or more of the following: a single attorney for all matters, different attorneys for different matters, a person to act for an attorney for a matter or all matters in circumstances stated in the enduring document. For instance, just as I've mentioned, just to sell their land, for instance. Alternative attorneys, successive attorneys, joint or several or joint and several attorneys for a matter or all matters. That's probably the most common. Or two or more joint attorneys for a matter for all matters. That's probably the second most common one. So when does an enduring power of attorney start? Section 33 of the Act defines when an attorney's power is exercisable. So principal may specify in the enduring power of attorney document a time, when, or circumstances in which, or an occasion in which a power for a financial matter is exercisable. If the enduring power of attorney does not specify a time, as I said, the power becomes exercisable once the enduring power of attorney is made. For personal matters, an enduring power of attorney will only come into effect once the principal has lost capacity to make those personal decisions. An attorney in that instance may ask for evidence, for example, a medical report or a medical certificate, to establish that the principal has indeed lost capacity and has the impaired capacity. So the next two slides are what powers cannot be given. So we have already seen that an enduring power of attorney gives the eligible attorney the power to make decisions about financial, personal and healthcare matters. An attorney cannot make decisions about special personal matters or special healthcare matters on behalf of the principal. These special personal matters is defined under the Act, Schedule 2, Part 2 of the Act to be precise, and it relates to, for instance, making or revoking the principal's will. So an attorney cannot do that. Attorney cannot make or revoke a power of attorney or an advance health directive or an enduring power of attorney. You cannot exercise the principal's right to vote in a Commonwealth or state election or local government election for that matter. An attorney cannot consent to adopt a child, cannot consent to marriage of the principal, cannot consent also to enter into a civil partnership or a termination of a civil partnership, or enter into a surrogacy arrangement on behalf of the principal. Also, special healthcare matters are defined in the Act as well. That includes an attorney cannot consent to the removal of tissue from the principal while alive for donation to someone else, the sterilisation of the principal, the termination of pregnancy of the principal, participation by the principal in special medical research, for instance. As I said, that's defined in the Act. And other prescribed healthcare of the principal. Slide 15, revoking an enduring power of attorney. Section 47 of the Act states that the principal may revoke the enduring power of attorney at any time the principal is capable. However, the principal must have capacity to revoke. So if the principal is a person of impaired capacity, he or she cannot revoke the enduring power of attorney. Section 50 states that an enduring power of attorney can be revoked by a later enduring document of the principal to the extent of the inconsistency. The death of the principal revokes the power of attorney, enduring power of attorney. The marriage of the principal only if the enduring power of attorney gives power to someone other than the principal's wife or husband. The same with civil partnerships. Divorce revokes the power of attorney if the principal divorces after making enduring power of attorney. The enduring document is revoked to the extent it gives power to the divorced spouse. And of course, Section 54, a power of attorney, enduring power of attorney is revoked according to its terms. So that means if the document is expressed to operate for a particular term or purpose, after that term or purpose has been completed, then it's automatically revoked. An enduring power of attorney can also be revoked by resignation or death of the attorney if the attorney becomes a person who has impaired capacity or becomes a bankrupt if the attorney is given power for financial matters. If the attorney becomes a paid carer or health provider of the principal, and also the revocation of the power must be in the approved form, lastly. So the effect of the power ending. So if an attorney's power ends and the attorney was a joint attorney, for instance, as we mentioned above, it can be in many ways. It can be jointly, it can be successively, you can appoint more than one. Then in that instance, the remaining attorney may still exercise the power, and if there's more than one remaining attorneys, then, and if more than one, then they can exercise the power jointly. So responsibilities of attorneys. So as well as complying with the terms of the power of attorney document, there are certain duties that attorneys must and may do on behalf of the principal. So, according to Section 85 of the Act, an attorney for a financial matter must keep and preserve accurate records and accounts of all dealings and transactions made under the power. An attorney for a financial matter must keep the attorney's property separate from the principal's property. Section 66 of the Act, the attorney must act honestly and with reasonable diligence. The attorney must, for financial matters, if given power for a financial matter, may invest in authorised investments, and the authorised investment is defined in the Act. An attorney for a financial matter for an individual may provide from the principal's estate for the needs of a dependent of the principal. Also, in certain circumstances, an attorney may gift as part of the exercise of their power on behalf of the principal. Section 88 allows the attorney to make a gift to a relation or a close friend of the principal. Gifts value, provided the gift's value is not more than what is reasonable. And also, the attorney can make charitable donations on behalf of the principal. The attorney may avoid conflict transactions. So a conflict transaction is defined in Section 73 of the Act. It's where the best interests of the principal are at odds with the interests of the attorney. Section 73 states that an attorney for a financial matter may still enter into a conflict transaction only if the principal authorises that transaction. So examples of a conflict transaction include, for instance, a conflict transaction happens if an attorney for a financial matter buys a principal's car. For instance, that's in the Act. A conflict transaction does not occur if an attorney for a financial matter is acting to maintain the principal's dependence. Confidential information. An attorney must not use confidential information because of being an attorney. That's defined in Section 74A of the Act, or because of an opportunity given by being an attorney. There is a penalty as defined in the Act. The maximum penalty if an attorney has been found to do this is 200 penalty units. Confidential information is defined in the Act, it's Section 74, and includes information about personal affairs of a principal, but does not include information already in the public domain. So Section 74A of the Act sets out certain situations where confidential information may be used by an attorney. These are, for instance, if it's authorised or required under regulation or another law, for proceedings arising out of in connection with this Act, if it's necessary to prevent a serious risk to a person's life, health or safety, for the purposes of obtaining legal or financial advice, if it's necessary to obtain counselling advice or other treatment, in reporting a suspected offence to a police officer or assisting police in the investigation, and assisting the public guardian. So all of that is defined in Section 74A of the Act. This brings me to the presumption of undue influence in Section 87 of the Act. So this states that the fact that a transaction is between a principal and one or more of the following, for instance, an attorney acting under an enduring power of attorney or advance health directive, in relation to business associate or close friend of the attorney, it gives rise to a presumption in the principal's favour that the principal was induced to enter the transaction by the attorney's undue influence. So in every transaction or decision that the attorney makes, it is presumed that the principal was induced to enter into that transaction by the attorney. So it is quite onerous. If the attorney does not act according to his or her obligations, Section 106 of the Act states that attorney may be ordered by a court to compensate the principal, or if the principal has died, the principal's estate, for a loss caused by the attorney's failure to comply with this act in the exercise of his or her power. This section of the Act permits a person whose benefit under a principal's estate may have been lost because of the actions of an attorney to apply to a court for compensation from the principal's estate. However, there are some relief contained in the Act, Section 105 of the Act, that relieves an attorney from personal liability. And these are, if the court considers A, an attorney is or may be personally liable for a breach of the Powers of Attorney Act, and the attorney has acted honestly and reasonably and ought fairly to be excused for that breach, the court may relieve the attorney from all or part of the attorney's personal liability for that breach. Now we come to our first case. This case is RERPB 2013. It's a QCAT case. The facts appear on your slide, and I'll just quickly go through that. Betty is an 86-year-old. She has two sons, Peter, who lives in California, and Robbie, who lives in Townsville. In 2012, Betty gave her enduring power of attorney to her brother John and her son Robbie. After Betty fell and broke her hip, she decided to sell her home and move into residential care close to Robbie. Robbie then sold Betty's home but did not consult Peter. The issues are, in this case, the issues are, did Betty have capacity to grant the power of attorney? And did Robbie act in a way that is inconsistent with his duties as Betty's attorney, i.e., obviously by selling her home? First issue, did Betty have capacity to grant the power of attorney? The tribunal heard from the solicitor who witnessed Betty's power of attorney document. The solicitor believed her to understand the effect of the document. On the day that the enduring power of attorney was granted, Betty's GP believed her also to have capacity to make the document. Betty's GP said, and I quote, "She is mentally sound and orientated to time, space and person. I believe she's capable of making decisions regarding the appointment of a guardian in her affairs, and I believe that she understands the process and able to make her own decisions." There was a doctor who attended to Betty after her fall, who also gave evidence and stated that he did not think she had dementia, and that Betty had expressed that it was not feasible for her to return home, and that she was happy with her decision to move into a nursing home in Townsville. A doctor also reported on Betty's cognition and stated she fully understands the legal constructs and reasonably foreseeable consequences of the decisions that she has undertaken. She demonstrates capacity for decision-making. The second issue was, did Robbie act in a way that is inconsistent with his duties as Betty's attorney? The tribunal heard the following. Robbie used $885,000 from the proceeds of the sale of Betty's home to pay her accommodation bond at RSL Care, where she was living in Townsville. Robbie invested also $155,000 in interest-bearing deposit for Betty. Robbie used funds to purchase Betty a car that is fitted with wheelchair access. Robbie had left the balance in Betty's funds in her personal bank account. And Robbie also ensured that Betty would be receiving excellent care and had Betty's solicitor read the RSL care contract prior to signing on Betty's behalf. The tribunal decided the following. The matter was dismissed. They were satisfied of Betty's capacity to give powers of attorney. The tribunal's primary concern is for Betty's welfare. There was nothing to support Peter's claim that Robbie was not acting in a way inconsistent with his duties as Betty's attorney, and the enduring power of attorney remains valid. The next case is RFG 2019. It's a QCAT case. The facts appear on your screen and the slides. I'll just read through it briefly. On the 1st of June 2014, RFG is diagnosed with moderate Alzheimer's dementia. RFG was placed in a Bupa nursing home as her ability to care for herself has declined. On the 13th of January 2018, 4 years after she was diagnosed, she signed an enduring power of attorney appointing family members as her attorneys for financial and personal health matters. This EPOA, enduring power of attorney, was to operate immediately. When RFG moved into the nursing home, her attorneys were obligated to lodge an assets and income assessment with Centrelink to determine fees. Bupa's policy in the absence of an assessment is to charge full fees. An assessment was never lodged, and RFG was charged full fees of which she cannot afford. Now she has substantial debt. The issues that QCAT was required to decide. The first one was the issue of the validity of the enduring power of attorney, where the principal, RFG, had been diagnosed with moderate dementia 3 years previously. The tribunal heard that the family had no up-to-date medical records to rebut the diagnosis that the principal had moderate dementia as early as the 1st of June 2014. The family confirmed that RFG's abilities had continued to decline since her diagnosis in 2014, and evidence from both RFG's GP and geriatrician was that she lacked capacity for more complex decisions. Eventually, the tribunal found that executing the enduring power of attorney to be a complex decision, the presumption of capacity for personal and financial matters is rebutted. Therefore, they decided that RGF did not have capacity to execute the enduring power of attorney some 3.5 years later. They therefore decided the enduring power of attorney is invalid. The second issue was the outstanding nursing home fees and the need to appoint an administrator. So RFG owed the nursing home $56,000. The family could not explain why the assessment was not lodged. The RFG's family had been unable to manage her financial affairs. The tribunal heard that without an administrator appointed, RDF's needs would not be adequately met or her interests adequately protected. The public trustees was appointed as administrator. QCAT also made some observations about JP's practice for witnessing enduring powers of attorney. So in this instance, JP attended the nursing home to witness the enduring power of attorney. RFG's diagnosis was 3 years prior to execution, as we've said, to that enduring power of attorney document. So JPs do not have training in relation to assessing an individual's capacity. In this instance, the JP could not provide any notes from when he or she had witnessed the enduring power of attorney for RFG. In conclusion, the tribunal found that RFG was not in a position to read the enduring power of attorney document, let alone understand its condition in 3 years later. Member Johnson on the 29th of March 2019 stated, tribunal member, it is necessary, and I quote, it is necessary to distinguish between the mere capacity to understand information and actual understanding. Merely having the capacity to understand is not sufficient consideration for actual understanding. In this instance, the tribunal also made recommendation to the Justice of the Peace when witnessing the enduring power of attorney documents, such as obtaining a medical history of the principal and their capacity, reading the Public Guardian Office guidelines for witnessing enduring documents, which is quite helpful and detailed, and also keeping notes. A tribunal also decided the need for RPG to have a guardian appointed. The family in this case confirmed that there was no issues in the care RFG was receiving from her nursing home. She also had a statutory health authority regime was explained to the family. RFG's family indicated that they would act on healthcare decisions on an informal basis and would notify the nursing home of any agreement or arrangement for healthcare decisions. The tribunal found that RFG had several family members that were able and willing to assist her in making healthcare decisions. In summary, in this case, the enduring power of attorney document was invalid. The Public Trustee of Queensland was appointed as administrator for all of RPG's financial matters and is to provide a financial management plan. The advised justice of the peace care that is taken when justice of the peace to take care when witnessing enduring documents, and the application for a guardian in this instance was dismissed. Okay, let's talk about advanced health directives. These are often referred to as living wills. So as you see from your slide, the Advanced Healthcare Directive is a document written while a person has capacity and for the purpose of acting as a substitute decision maker at a later time when they no longer have capacity. The document specifies what healthcare decisions a person wants in the event they can no longer make those decisions for themselves, including directions relating to life-sustaining measures. It can be as detailed as you wish, however, it cannot authorise euthanasia. Section 42(1) of the Act refers to healthcare directives. It states that a principal may make a healthcare directive to the extent it does not give power to an attorney only if the principal understands the following matters: the nature and likely effects of each direction in the Advanced Health Directive. The direction only operates while the principal has impaired capacity for the matter covered by the direction, and the principal may revoke a direction at any time provided the principal has capacity for that direction. A principal may also make an advanced health directive to the extent it gives power to attorney only if the principal also understands the matters necessary to make an enduring power of attorney document giving the same power. Section 36 of the Act states that a direction in the healthcare directive to withhold or withdraw a life-sustaining measure cannot operate until the principal has a terminal illness or condition that is incurable or irreversible, and as a result of which, in the opinion of the doctor treating the principal and another doctor, the principal may reasonably be expected to die within 1 year. The principal is in a persistent vegetative state. The principal is permanently unconscious, that is in a coma, and there's no reasonable prospect of the principal regaining consciousness. The principal has an illness or injury to such severity that there is no reasonable prospect that the principal will recover. And for a direction to withhold or withdraw artificial nutrition or artificial hydration, the commencement or continuation of the measure would be inconsistent with good medical practice. And the principal has no reasonable prospect of regaining capacity for healthcare matters. As I said, that's defined in Section 36 of the Act. Now, as I mentioned, although the healthcare directive can be as detailed in relation to the above matters or healthcare matters as a principal would like, it cannot authorise euthanasia. Section 37 of the Act makes it clear that an advanced health directive does not do that, cannot do that. Euthanasia is an offence under the Criminal Code. So who can prepare an advanced health directive? Any person over the age of 18 and has capacity can prepare an advanced healthcare directive. There are some formal requirements, however. Section 44(6) of the Act states that the advanced health directive must be in an approved form. It must be signed by the adult principal, a doctor, and a witness. It must also include a certificate signed and dated by a doctor stating the principal, at the time of making the advanced health directive, appeared to the doctor to have the capacity necessary to make it. The doctor must not be a person witnessing the advanced health directive. It must not be the person signing the advanced health directive for the principal. Must not be an attorney of the principal. The doctor must not also be a relation of the principal, or a relation of the attorney of the principal, or a beneficiary under the principal's will. Section 50 of the Act states that if there is a direction about a health matter in an advanced health directive and a later enduring power of attorney gives an attorney power for the health matter, the direction prevails. As you can see in the next slide, what kind of decisions does it provide for? It provides for information health professionals should know, for instance, health conditions, allergies, religious, spiritual, cultural beliefs that would affect the principal's care, current and future health decisions, as we talked about the differences between an advanced health directive and an enduring power of attorney. Enduring power of attorney is more general and gives the attorney power to make all health decisions. As we've just noted, advanced health directive is very specific about the wishes for a principal. Advanced health directives are particularly useful to assist an attorney when they are uncertain about making a decision, and that way an attorney can simply refer to the advanced health directive that has already been prepared. Revocation. The advanced health directive can be revoked only while the principal has capacity. It can be revoked by advising. If it is revoked, the principal must advise all attorneys under the document of the revocation in writing or make a new directive that is inconsistent with the first. It cannot be revoked, as we said, if the principal becomes a person with impaired capacity. In these circumstances, an application must be made to the tribunal. Next, we look at another case called Hunter and New England Area Health Service versus A. It's a 2009 case. The facts are, A was a Jehovah's Witness. A completed a worksheet that expressed his refusal for dialysis treatment should he ever require it. 1 year after A completed this document, he was admitted to hospital suffering from septic shock and respiratory failure. A was treated by mechanical ventilation and kidney dialysis. The hospital became aware of the worksheet and sought a decision from the court as to whether A's worksheet was considered an advanced health directive. And the court decided that the worksheet was a common law advanced health directive and should be treated as such. This decision is Supreme Court judgment of Justice McDougall. It's important because it summarises the legal principles surrounding the status of advanced health directives and emergency care decisions. In this case, Justice McDougall made clear that this case was not concerned with any notion about the right to die. That is, so even if the likely consequences of giving effect to A's wishes, as expressed by him, is that he will die. Justice McDougall stated, and I quote, "A person may make an advanced healthcare directive, a statement that the person does not wish to receive medical treatment or medical treatment of specific kinds. If an advanced care directive is made by a capable adult and it is clear and unambiguous and extends to the situation at hand, it must be respected. It would be a battery to administer medical treatment to the person of a kind prohibited by the advanced care directive. Again, there may be qualifications of this treatment if necessary to save the life of a viable unborn child." I recommend that you consider reading this case. It is quite interesting, especially Justice McDougall's comments about emergency care decisions. Next, we move on to statutory health attorneys. Section 63 of the Act sets out in priority the categories of people that are authorised to make health matter decisions for a principal. These are people that are readily available and culturally appropriate to exercise power. Number one, the spouse of the adult, if the relationship between the adult and the spouse is close and continuing. And a person who is 18 years old or more who has the care of the adult and is not a paid carer for the adult. 3, a person who is 18 years or more and who is a close friend or relation of the adult and is not a paid carer. If no one listed is readily available and culturally appropriate to exercise power for a matter, the public guardian is an adult statutory house attorney for the matter. So if you've seen in your slides, a statutory health attorney is where an adult with impaired capacity has not appointed an attorney nor made an advance health directive for health matters. Power is exercisable during any or every period the adult has impaired capacity for the matter, does not include a special health matter. And there's no formal procedure to appoint a statutory health attorney. There's no documents to fill out or anything like that. If there is a disagreement about which of two or more eligible people should be the statutory health authority or how the power should be exercised, the public guardian may exercise the power for the health matter. That's contained in Section 42 of the Guardianship and Administration Act. The public guardian also can mediate disputes between statutory attorneys. Now, I'd like to just touch briefly about the relationship between the Powers of Attorney Act and the Guardianship and Administration Act 2000. There is a relationship. Section 68(1) of the Act is to be read in conjunction with the Guardianship Act. It provides a scheme by which the tribunal may appoint a guardian for an adult with impaired capacity for personal matters, to make particular decisions and do particular other things for the adult in relation to the matters. The tribunal may appoint an administrator for an adult with impaired capacity, and the tribunal may consent to the withholding or withdrawal of life-sustaining measure to a particular special health care matter. The Guardianship and Administration Act also provides for the public advocate. A section of the Act, Section 6A(4) of the Act, states that if there is an inconsistency between both Acts, then the Guardianship and Administration Act prevails. Briefly, what remedies are available? So, applications to the court. An application can be made for a declaration, order, direction, recommendation or advice about something in or related to this Act, the Powers of Attorney Act. There's certain people that can make an application to the court, Supreme Court. It's the principal, a member of the principal's family, an attorney, the public guardian or public trustee, an interested person, which is not defined in the Act, and the public guardian or healthcare provider for the principal. However, only if the document is an advanced health directive and the application involves power for a health matter. The court has wide and varying powers. It may make a determination of capacity, make a declaration about commencement of the power, order removing an attorney or changing or revoking the document, change circumstances as basis for change or revocation, give advice, directions or make recommendations, and dismiss applications, obviously. On an application by a person the court considers has sufficient interest in obtaining reasons for its decision, it may give reasons as well for a decision. These will be made within 28 days after the application. And in relation to costs, the costs of the proceeding are within the court's discretion. All right, that brings me to the end of our presentation. If anyone has any questions, happy to take them.
We've had one question sent in advance. Feel free to type your questions into the question box while Laura answers this one.
Sure.
So the question was about transferring an enduring power of attorney to another state in Australia.
Okay, so that is covered under Section 34 of the Act, I believe. So that is recognition of enduring powers of attorney made in other states. For instance, if an enduring power of attorney is made in, say, Victoria, it can be exercised in Queensland, say where the principal lives or where the attorney lives, or where there's property, say in Queensland, provided it's been executed and drafted according to the powers in Victoria, it's valid in Queensland.
All right, thank you, Laura.
No problems.
So we've had another question come in. It's when the enduring power of attorney is being executed, does the principal have to be alone in the room with the witness?
Probably for good practice, I would say yes. It just because there's that there is that clause in the Act about undue influence. So when executing the enduring power of attorney, it should be done. The witness doesn't have to be in the same room, so the principal can sign the enduring power of attorney document, and then the witness can sign later. But if the attorney is a family member or as a matter of practice, I always like to have the principal in the room with me and the attorneys outside of the room.
We've just had another question come through. It's when a person gives financial power to their attorney immediately, but they still have the capacity to make decisions. Does the attorney need to consult the principal when making financial decisions for the principal?
I think if you're an attorney and you know that your principal still has capacity to make decision, it's really good practice on the attorney to consult the principal when making any financial decisions. That would be my view, although it doesn't seem to be anything in the Act that the attorney needs to consult. But I suggest that as a matter of good practice, and as I mentioned before, the issue about undue influence, that it's presumed, I would suggest that if the principal still has capacity, then the attorney should consult with the principal.
Yeah, it's important to keep up good practice and make sure we're doing everything right here.
Yes.
So we'll just see if any more questions come through for a minute. Feel free to type anything into the question box. All right, well, it looks like Laura's presentation has answered all of your questions, which is really great. Thank you to everyone for attending today, and a big thank you to Laura for such a great presentation. I definitely learned a lot, and I'm sure all of you did as well. If you have any more questions, feel free to just send them through and I can forward them.
Yes.
Thank you, everyone.
Thank you.